let's go through your higher education process. Where did you obtain your BUris degree and where?
Chief Justice, I obtained my BUris degree in 1994 at the University of the Free State.
Yes. Please put the mic a bit closer. What did you then do?
Then I started with the LLB course, also at the University of the Free State in 1984. Started during 1985 with the LLB for the next 3 years.
But at the same time, you caused articles of clerkship to be registered?
I did in my second year of my LLB course. I started with the articles at Nudia's attorneys in Bloemfontein, now Pachuanieni.
At those days, how much did they pay per month?
Chief Justice, I started off with a salary of 500 Rand per month.
Yeah, that sounds like it.
Yes.
And what then did you do after obtaining your LLB degree?
After obtaining my LLB and finishing the articles at Nudia's attorneys, I left and joined another attorney's firm in Bloemfontein for a period of 1.5 years.
Yes.
And then I did my practical exams and was admitted as an attorney.
Yes.
In October.
And were you treated with the respect you deserve as a woman? Were they gender sensitive, or were there the typical challenges that women experience in a work environment?
There were challenges. At this stage, when I started my articles, we were 2 female article clerks at the particular firm. A lot of the young men that started with me just finished the training at the army training. So it was difficult because we were in the minority. But I have to say, during that period, one of the partners at the firm said that he believes in future they will appoint more female article clerks because the females tend to be more conscientious of their duties.
Yes.
I don't know whether, but maybe it was true.
What made you leave the attorney's profession and become an advocate? In 94, I think you left.
Yes. What convinced me at that stage was my mentor, Mr. Grobler at Symington and de Kock Attorneys. He joined the bar, and then he actually convinced me to also join the bar.
Yes. And upon joining, was there support available? Briefs? Were there briefs available to you? Did at least your old firm give you the support you needed to stay on?
Yes. At the beginning, what we did those days were mostly what we refer to as pro deo cases. Yeah. So that kept us busy. At this stage, I think it was during 1998, 1999. The system, however, changed because in the beginning, after finalizing a criminal matter, we would submit the account with the registrar and we were paid immediately. Yes. But then the system changed and you had to submit your account with the legal aid board.
Yes.
And that caused a bit of problems
Took
later.
too long, eh?
It took long, and that was the reason why I resigned also as a member of the bar. I didn't receive any income from the legal aid board for more than 1 year.
Yes.
And that caused a bit of financial, and that was the primary reason why I resigned. I didn't want to incur further debt at the bar.
What made you come back after leaving in 1999?
Looking back, I think it was detrimental to my career to not be a member of the bar. And at that stage, during 2011, I was remarried because my first husband passed away in 1985. So I was remarried and I had little backup, financial
Yes.
backup. My husband actually convinced me to rejoin the bar.
So your stay at the bar, excluding the 2-year period over which you were away as family advocate, I think, is 23 years.
Yes, Chief Justice, the appointments at the office of the family advocate I was still practicing as an advocate.
Okay.
It was contract periods for 1 month at a time. So I didn't
Yes.
have a office at the family advocate office. I just went there from home and to do the interviews and to compile the reports.
Okay. Okay.
So it was not I was not working actually full time for the family advocate office.
Yes. I know that briefing patterns are challenges, particularly for women, but any reason why you didn't take silk after 2 decades of practice as an advocate?
It crossed my mind several times.
Sure.
But in the Free State, work for silks I believe it's not that often that
Yes.
that you get the opportunity, especially being a woman as well.
Yes.
So and you move into a total different structure, fee structure.
Yes.
So
Yes.
I was confident to stay within the limits that I knew without taking the
Yes.
decision to apply for silk.
You didn't want to kill your practice, in other words.
Yes.
Yes. Why, in your own words, do you believe you're ready for this position? Just very briefly tell us why you believe you're best equipped, even comparatively speaking, for this position. In other words, if you're minded to, even compared to the other two,
Yes.
why you, in your own words?
Chief Justice, I was contacted by our previous Judge President, Justice Molamela, and she requested me to consider acting and accepting an acting appointment. She actually said, I'm not going to take no for an answer. And since the acting stints during last year, the beginning of this year, and actually I was in court last week for 2 days as well, presiding over a parted civil matter, I really enjoyed the experience. I believe that through my qualifications, the period of experience at the bar, that I am equipped, and I enjoyed the job. It was challenging. It's a lot of work. It's hard work, but I think that is the reason why I enjoyed it.
What is the longest period you've reserved the judgment for?
It was more than 2 months, nearly 3 months.
But that you've never gone beyond, say, 6 months or something?
No.
Yes.
I've not gone beyond 3 months.
Yes. Thank you very much. JP?
Thank you, Chief Justice. Ms. van Rhyn, the second husband that you are referring to is currently the second most senior silk at the Free State Bar.
Yes, indeed so.
Now, there is a very high attrition rate, especially when it comes to black women at the Free State Bar. It's like a revolving door. They come in and then they go and they're lost.
Yes.
What, in your view, are some of the reasons?
The problem is to keep your practice going, especially in the beginning, during the first 2 years. Payment of fees are a bit slow. at present, and many of our junior members are relying on RAF instructions. And presently, I think it's the same problem that I experienced many years ago. The RAF paying is a bit lacking behind, so they wait. The junior members wait almost a year before getting paid for their legal services. Another aspect is due to the transformation process also, a lot of the black members, not only the females, but also the members of color, males, are being appointed in the private sector due to their qualifications as qualifying as after the pupillage and being admitted as an advocate. And obviously it provides more financial security to receive a monthly income.
And is it not so that we have always pleaded with the bar to think out of the box and come with some sort of interventions to keep them there?
Yes.
Because the problem with the Free State is that the attorneys there are predominantly white and they don't just brief the black women.
Yes.
Okay, fine.
I'm sorry,
Sure.
JP. What happened already, I think in 2003 or 2004, is there's a fund made available for our junior members, and everybody contributes to that fund. So junior members who experience a bit of financial problems may apply for financial assistance, and I believe that will assist in future. But I have to say that in my experience during the past 5 years, there's been a change in the briefing practice and briefing patterns, and I believe it will increase in future as well, because the new attorneys, the young attorneys, they are getting used to briefing women. So there's more and more women joining the bar. This year, there's 2 black young female women presently busy with their pupillage, and I believe waiting for the results of the exam.
The fund that you're referring to does not target women or blacks. It's a fund for all juniors.
Yes, yes.
And lastly, you know that the demographics in the Free State when it comes to women is that we currently have 3 white females, 2 black females, and 1 Indian female.
Yes.
Would your appointment, in your view, benefit the province when it comes to transformation in terms of gender?
In terms of transformation regarding gender, yes, because I'm a female, but the other objective in terms of section, I think it's 174 of the Constitution, is also transformation regarding race.
What the second question I want to ask you?
Yes. Yes. I was shortlisted. I'm here. The decision to appoint to appoint a judge for the position available is a decision, and it's one of the aspects that this commission has to decide upon. Surely, it's important to transform the bench in the Free State. That's crucial, and I agree with it, and I accept it, and I support it.
Thank you, Chief Justice. I have no further questions.
Thank you, JP. MEC?
Thank you, Chief Justice. Me Advocate Ilse van Rhyn.
Commissioner.
Dumela.
Dumela.
I see that you have acted quite several times.
Yes.
And I note that your husband serves as a senior counsel in the Free State Division.
Yes.
Could that somehow have given you an added advantage to be acting against many others who are complaining that they do not get an opportunity to act. Could it possibly?
We have an influence.
Yeah.
I doubt it.
You doubt it.
I do not think that was one of the criteria that Justice Molamela took into.
Okay.
I don't think that was one of her considerations, that my husband is a senior advocate, to ask me, and I doubted whether it was one of the considerations of our present JP.
Okay. I've noted through your own submission, as you were speaking here, that for you to step out and do something, you have to be pushed or encouraged, firstly by your husband, hey, go and do this and all that. And then President Molamela had to say, I'm not taking a no from you.
Yes.
I sense some reluctance and that you have to be nudged before you could, step out. Why is that?
I do think it's due to the history, due to, and I do accept it as detrimental to me that I resigned as a member of the bar in 1999. It was detrimental to my further career. And I'm always aware of that fact, that actually I was one of those who didn't make it at the bar at that stage. So it's always in my mind, but the opportunity to act as a judge in the Free State Division provided me with much more confidence.
So do you feel that because of the history, at times you are disadvantaged?
Yes, certainly at times, yes. But I have to add that there were many white male advocates, attorneys who briefed me, white male, especially my mentor at Symington and de Kock, who encouraged me, definitely, without a doubt.
But do you believe that this country needs to deal with the transformation in terms of fair representation and ensuring that the demographics of the country are reflected?
Indeed, I do.
You do?
I do,
Okay.
definitely.
Thank you very much, Judge President.
Thank you, Honorable MEC. Commissioner Msomi.
Thanks, CJ. Good afternoon, Council.
Good afternoon, Commissioner.
Yes. It is generally accepted that ours is a progressive constitutional state, and obviously it requires progressive judges to interpret the constitution that we have,
Yes.
which has been hailed as one of the best in the world. What values are you bringing to the bench in a state like ours, which has been hailed as a progressive constitutional state?
I listened to the interview with Justice Cameron, a section of the interview with Justice Cameron after his retirement, and he said that he believes that every judge on the South African bench should be an activist for justice and for equality and freedom and all the other values enshrined in our Constitution. And I agree that judges should be activists for justice. And in so being, a judge will be mindful of what happened in the past and to apply the law and to ensure equality in the future. And I'm mindful of being impartial and to apply the law. And the Constitution being the supreme law, that is one of the objectives.
And have you had an opportunity to develop our common law to be in line with the new? Have you decided any matter?
No, I haven't had that opportunity.
Just on a lighter note, MEC greeted you in Sesotho and you greeted her back. Do you speak the language as a matter of interest?
No, I don't. I don't.
Thank you.
Thank you, Commissioner Msomi. Commissioner Skok.
Thank you, President. The BLA says you have not gained enough experience to be considered. The GCB says the judgments that you have considered did not invoke issues pertaining directly to constitution and constitutional law. What is your comment?
Regarding the first aspect, it was mentioned in that comment that I acted less than the required period. But if you take into account, Commissioner, I acted for a period of 9 weeks initially, and then the last term of 2018, the first term of this year, and since the 2nd of May, the whole of May, for a period during July, also for 2 weeks in Virginia with a partnerhood matter, and I was in court last week as well. And when calculating those weeks, it comes to a total of just less than 10 weeks, excluding the 2 weeks that I still have to go back to Virginia for the partnerhood matter. So I don't know whether that answers the first question regarding the period that I've acted. Second question.
The GCB about you invoking the Constitution.
The Constitutional Court. Actually, in preparing for this interview, I read the judgments that I wrote, and I saw that in most of the judgments I refer to the Constitutional Court and the application of the principles of the constitutional law. I applied. So actually, I realized that the estimation of work regarding constitutional law that I gave in my application form, it has to be more than that, more than 15 to 25%.
Thank you. In response to JP, you indicated that in the bar there were members of color.
Yes.
I want to understand, what did you mean that there were members of color?
Well, we have black members, and we've got an Indian male member. He's actually my neighbor. And then we've got a colored female also.
So in
So
short,
it's members of color, just not black, all black members. There's also an Indian member, and that's the only way that I refer to.
so you were referring to black people as members of color?
Including black people and an Indian lady, and an Indian male member, as well as a colored female member. Those members of color.
President, if you may allow me to...
They are becoming 4 now. That would be the 4th.
It is a follow-up on this one and the last one. Thank you, Chief Justice, for the indulgence. The concept of people of color comes from the US,
Yes.
where black people are in the minority, and they were referred as people of the other color. And here in South Africa, they are in the majority, and
Indeed.
still the minority refers to them as people of color. How do you reconcile that?
I did not want to refer to the non-white members at the bar as the black members, because it also included an Indian member, a member of the Indian race, as well as a colored female. And that's the only reason that I referred to members of colour, not due to any other reason.
Thank you, Chief Justice.
You may wish to reflect on the use of the terminology non-anything. If you say something is non, it means there is a standard that you have failed to live up to. You are non that standard. And I know
understand
you are
that's not-
innocent, you're just using it. You don't
Yeah.
mean any harm.
No,
But words are very important. Commissioner Norman?
Thank you very much, Chief Justice. Good day, good afternoon, Ms. Rhyn.
Good afternoon,
Yes.
Commissioner.
There's just a period in your application. I've tried to look at the years. There seems to be a period that's unaccounted for. May I just draw your attention to page 21? Do you have your
I beg your pardon, I do not have a
any
copy.
bundles? Oh, sorry.
I haven't got any.
No bundle for her.
Maybe you could just mention the year.
Maybe I'll be
yes.
able
Yeah,
to
just
remember.
mention the year, she would
Yes,
know.
thank you, Chief Justice. At page 21, you've put in October 1999, resigned as member of the Free State Society of Advocates and commenced practice an independent advocate. And then you've got March to April 2003 as acting magistrate, domestic violence court. And then you have 2005 to 2004 and 2005. Then from then, you rejoined, there you were a family advocate.
Yes.
And then you rejoined the Free State Society on the 1st of November 2011. But there's a period 2005 to 2016 that I can't find when I look at your documents.
I understand. Commissioner,
Yes.
from my resignation as a member of the bar at the end of 1999, I continued to practice as an advocate. I just practiced from home throughout the whole period.
Okay.
So I never stopped practicing as an advocate.
Oh, so in essence, what you need to put in would be from 2005 until 2016, where, I beg your pardon, 2006 up to 2011 when you rejoined, also continued as an so-called practicing independently of the bar.
But it includes the period when I was appointed at the Family Advocate. As I explained, the appointment at the Family Advocate was for a contract period. I just went to their offices to conduct an investigation, and then to write the report while not at the office or at the Family Advocate. So I just used their office to conduct the investigation and then.
Then you were practicing outside the
during
bar.
that time, I continued to practice as an independent advocate.
All right, thank you.
Throughout the whole period since I joined the bar in '94, I
All right.
practice as an
Yes.
advocate until today.
Thank you. Just one aspect there is a judgment that you've attached. Well, it's an appeal judgment. The Coram Matebula J, Opperman J, and Van Rhyn J. No, I'm so sorry. No, I think, I beg your pardon, Chief Justice, sorry. I opened the first page on a wrong page. I beg your pardon. This one is Matebula J and Van Rhyn AJ, 23rd April 2018, and it's the... no, man. No. Please forgive me.
No problem.
The judgment I want to refer you to is the Carl Jacobus van Heerden versus Scoin Trading, page 159, President. Page 159.
Yes.
Thank you. I would like to draw your attention to paragraph 4, which appears at page 160.
Yes.
This was a summary judgment application, am I
Yes.
right?
Yes.
I would like you to look at paragraph 4. On 22 November 2017, the defendant entered an appearance to defend the action. On 2 February 2018, more than 2 months later, the plaintiff gave notice of his intention to apply for summary judgment to be heard on 22 February 2018. In the usual supporting affidavit, the plaintiff stated this and that, and then we deal with that. Do you, by any chance, deal, because I couldn't find it, but I don't want to assume, maybe you did differently, deal with requirements in Rule 32(2) about when summary judgment can be brought, the application for summary judgment? Because what you deal with is the defense, but I don't see you dealing with the timing of the bringing of the summary judgment.
What I can remember in that case, there was a delay of time, but it was not one of the contentious aspects at the hearing of that application.
No, but 32(2) says the plaintiff shall, within 15 days after the date of delivery of notice of intention to defend, deliver notice of application for summary judgment together with an affidavit made by himself or by any other person who can swear positively to the facts verifying blah, blah, blah. Because once they are past the 15-day period, then you enter what is called the usual order, that summary judgment is refused, notice of intention to defend is then all of those orders. So I just want to understand on what basis then did you continue with it, seeing that at paragraph 4, it was very apparent that that was already out of time and it ought not to have continued as a summary judgment.
If I remember correctly, that application was placed on the roll previously and it was postponed by agreement, if I'm correct.
Yes, yes.
That was the reason for the time period that I did not reflect in the judgment.
Yes, but there's a critical time period, you agree with me? Because the rule makes it a shall, that you shall deliver your application for summary judgment within that period, 15-day period.
I understand.
Yes.
I cannot specifically remember the facts in that matter, but I know that that was not an issue that was argued or contested by any party.
Right.
That is all that I can remember.
Thank you. Thank you, Chief Justice.
Thank you so much, ma'am. President Meyer?
Thank you, Chief Justice. Good afternoon.
Good
Council.
afternoon, President Meyer.
What is the composition of the Free State Bar? Can you just give us a breakdown in terms of race and gender?
I think there's 13 senior members and 63 junior members. I think currently there's 14 black male members, and we are presently 13 female members. 2 new female black members from Johannesburg joined the Free State Bar during this year. And there's currently also 2 black female members who just wrote their practical exams, the admission exams, during August.
Can you just explain something I've found quite strange over the years? I've been at the SCA for 15 years now, and in all that time, I have very seldom seen members of the Free State Bar, including the senior ones at the SCA.
Yes.
It seems that the preference is given to practitioners from outside. Do you know why that is? Or maybe could it be lack of confidence in the skill down there?
It's possible. It's also possible that many of the cases that land up in the Supreme Court of Appeal is cases that originate from the other provinces. I've appeared in the Supreme Court of Appeal only once while it was still the appeal court for a criminal appeal. That was many years ago, and Judge van den Heever was still... So that was the last time, but I cannot really say why the senior members of our bar does not appear in the Supreme Court of Appeal on that regular basis. It depends upon the question from where the case originates, whether it's a Cape Town matter or from the Eastern Cape.
No, that includes even local matters. That's why I found it quite, odd.
That senior members from especially Johannesburg is briefed.
So you have appeared there only once in the early to mid 1990s.
Yes,
All right. Okay. Thank you.
thank you.
Thank you so much, President. Honorable Lucas.
Thank you very much, Honorable Chief Justice. Goeiemorgen,
Goedemiddag.
advocaat van Rhyn. Is het al middag?
Goedemiddag. Ja. Goedemiddag, Commissioner.
Ja, ek het gedink dat ek kom eens van die Vrystaat af, laat ons 'n bietjie Afrikaans praat. Now, my question is with regards to your experience in the gender-based violence area court, particularly if you look at how the issue of gender-based violence have become a very thorny issue,
Yes.
escalating, and
Indeed.
currently it's really a current issue that is concerning all of us. Even last week, I wanted to say it, but I didn't get an opportunity to say I am very much pleased that all the three arms of state is in agreement that more needs to be done with regards thereto. But my question to you is just to share a little bit of experience. If you compare what was put in place in that stage, 2003, around there, 2005, in comparison with what we are trying to do 2019, and how can you in fact advise us? I just decided to ask that generally because of your experience. Thank you.
When I started acting in last year, I was involved with a few, on a Monday, a few appeals, and I appeared in those matters with Judge Rampai, and all of them were rape cases, and I expressed my concern to Judge Rampai that it seems as if those cases are increasing. The rape cases, the rape appeals at the High Court, and he confirmed my observation that it is indeed so. There are more rape cases on appeal in the High Court, on the High Court roll. So in what we hear on the news and what we hear on the radio is in fact true. There's an outbreak and an increasing amount of gender violence, rape matters. I don't know what the reason for the increase is. I believe that social workers, people who work with those cases will be able to give the reasons for the increase, but it's a fact, it is happening. And the courts, people are looking to the courts to increase the sentences and to deal harshly with perpetrators of gender violence.
Well, just in passing, in your experience, if you look at the overwhelming majority of people accused of rape, would they be business people, wealthy people, learned people, or people who live in deplorable conditions, unemployed, shack dwellers, people whose dignity has been severely damaged? What is your experience? Not that it's an excuse, but where do we find the overwhelming majority of perpetrators of these offenses? And maybe that's where the root causes lie.
Yes, I do agree with the perception that it is people with sometimes no income, desperate circumstances prevailing, but it also appears within all
I was
ranges.
asking the overwhelming majority. Is it evenly balanced, or do you find more in people whose dignity has been severely undermined by the conditions in which they live? Do you find many professors, many teachers, doctors, magistrates, judges, people who don't lack, who live in reasonable accommodations?
No, it does appear.
Is it evenly balanced or not?
Definitely not.
That's what I was asking.
Yes.
Prof,
Thank you, Suji. Good afternoon, colleague.
Good afternoon.
You have a
Commissioner?
judgment you delivered last year, May, about the rape of a 5-year-old girl,
Yes.
where you dismissed the appeal.
Yes, I remember that
Ye-
matter.
Yes. My issue is the comment that you made. Other than the fact that the child was young and also 5 years.
Old at the time of the rape.
Yes.
Yes.
Do you still remember the case?
Yes, I do remember the matter. Yes, that was an appeal, and I sat on that matter with Judge Matabula. Yes.
your mic is off, Prof.
The concern that I have is that the jurisprudence is there, that when you approach the matters of this nature,
Yes.
you have to adopt a holistic approach.
Yes.
Although you have to tread carefully, but this is a 5-year-old child.
Indeed, sir.
Now, you found this child, that the evidence that she presented was not good enough to warrant the conviction, to an extent, an 18-year sentence. Yes.
Yes. Was overruled. Yes.
Yes.
It does not only concern the evidence of the minor child, who was 6 years old at the time when she gave the evidence. It was also the difference in the evidence presented by her sister and the evidence presented by the minor that caused doubt concerning the guilt of the accused. So you have to tread carefully when there's a minor giving evidence. The questions, and the questions presented to the minor, some of the questions I repeated in the judgment to explain the reasoning that some of the questions the child could not answer properly. Sometimes she would say yes to the same answer, and the next time the question was repeated, she would say no. So it caused doubt in my mind regarding the guilt of the accused. And Judge Matabula agreed.
It's fine, but it's not fine. We'll talk some more. Sure.
Advocate Masuku, the SC himself.
Hey, thanks, Chief Justice. Just to follow up on the question asked by Prof. The questions you repeated in your judgment are set out in paragraph 23. And I'll read them, but I won't read the issues that I don't want to read. As you say, on several occasions, the complainant faltered to respond to questions put to her in an appropriate way, and at times indicated that she does not understand the question. The following examples will illustrate the point. Yes, what happened then? And then the child says, he undressed and then inserted his inside my mouth. Okay, and then what did he undress? The child says his pants. Where in the shack were you when this happened? The child says, I was inside. Was there anything else in the shack? The child says, no, your worship. Then the court says, what was in the shack? She says, it was my sister's books. And did you see his, and he said, yes. What did it look like? and the child says, it was not okay. Can you describe it to us? She says, no. And what was he wearing when he inserted his in your mouth? And then he says he was wearing pants, your worship, trousers. And after he undressed, and she says, I do not know. And then your criticism of that evidence is that the complaint's answers to some of the questions posed to her indicates that her power of observation, recollection, and communication skills raises the question whether she has the capacity to understand the questions put to her and frame and express capacity to understand the questions put to her and frame and express intelligent answers in relation thereto. The reason for evidence to be given under oath, or as in this case where a child is admonished to speak the truth, is to ensure that the evidence given is reliable. Now, on what basis did you not believe this child, and on what basis did you suggest that these answers were answers that did not reflect a proper observation of what happened? Because as I read them, they are quite clear of what happened.
Yes, but those are not the only answers that the child gave during her evidence. On reading of the whole of the record, you get the impression, and that's the impression that I got, that this child was not able to relate what happened to her. And I discussed the matter with Judge Matabula before we delivered the judgment, and we came to the conclusion that it is possible that this child was influenced to give certain answers. And so in that sense, and taking consideration of the difference in the child's evidence and her sister's evidence, even Advocate Georgie, who appeared on behalf of the state, argued, leave the evidence of the sister and just concentrate on the evidence of the child due to the inconsistencies of the two witnesses. And that is the reason at the end that we decided to, due to the doubt that existed in our minds, not to convict, to
uphold the conviction.
Indeed,
Thank
sir.
you, Chief Justice.
Thank you,
Justice.
sir. Thank you. Commissioner Fourie.
Thank you, Chief Justice. Good afternoon. Goeiemiddag.
Good afternoon, Commissioner.
Advocate van Rhyn, I've got two questions for you. The one relates to part-heard matters and reserved judgments.
Just bring it closer, Commissioner
And-
Fourie, and
Sorry.
on the side you face when you speak.
I hope it's better now.
Yes, indeed, sir.
The one relates to reserved judgments and part-heard matters.
Yes.
The other one is just a transformation question. In your questionnaire, you say that you reserved two judgments in matters that were heard on the 2nd and the 3rd of May. Your questionnaire was completed on the 26th of June. I heard you earlier saying that you haven't reserved matters for more than 3 months.
Yes.
So can you give an indication when you gave judgment in those two matters?
Those judgments were delivered the end of July, the beginning of August.
Okay.
Both of those, it was, yes,
But still
3 judgments.
talking about those judgments, I see that during your acting stints, it happened that you had several part-heard criminal matters,
Yes, especially.
which you had to go back for, as well as a civil matter that you had to
Yes.
go back for.
Yes.
Is that the one you had to go back for last week?
No, the civil matter was the one that we finalized the evidence last week, and the matter was now postponed to the pre-trial roll for the record to be typed and for heads of arguments. So presently I do not have any reserve judgments.
Okay.
And this, I beg your pardon, the criminal matter was also disposed of in the judgment delivered already in July.
I appreciate the fact that matters can become parted.
Yes,
One obviously tries to avoid that at all cost.
indeed so.
But the two reserved judgments that I referred to, where you say you gave judgment in July and August, they happen to be opposed applications. But they were part heard and finalized on the 2nd and 3rd of May. My question to you is, just explain to me, how does a opposed motion become part heard?
It was actually three applications with counter applications as well, and the matters were placed on the roll in March, I think, and was postponed to be heard on the 2nd and the 3rd of May.
And my second question, I said, would it be a transformation one? You said that you understand the transformation agenda and that you are fully in agreement therewith. That's how I understood your question.
Yes.
And that's also how I perceived what you had to say here today. But hypothetically, if one has a situation where you have an African woman and a white woman equally deserve it, from a transformation point of view, what would you then do if, for example, there's one position to fill?
As you presented the criteria, then the position should go to the African woman.
Thank you, Advocate van Rhyn. Thank you for being here. Thank you, Chief Justice.
Thank you so much, Commissioner Fourie. Advocate van Rhyn, you are excused. Thank you so much, ma'am, for coming.
Thank you.
Thank you.